we have to highlight that an effective role of the victim in criminal proceeding has been recognized quite recently. This is why traditionally it was considered sufficient the role performed by the public prosecutor in criminal proceeding as a defender of the victims, because the trial was above all considered a wrong against the society. This idea has progressively changed because we consider now that, yes, crime is a wrong against the community as well as a violation of individuals' rights of the victims as a person. And in this perspective, the European Union decided to adopt a package that is called the Victims Package, the Budapest roadmap, that is a comprehensive package with a lot of legislative measures in order to strengthen the rights of the victim in criminal proceedings. And first of all, the paramount result is for sure the Directive 2012, number 29, on the rights of the victims. That it, the goal is to fix minimum rules on the rights of the victim in criminal proceedings. This directive marks a remarkable change of perspective. It's worth mentioning, for example, that the directive recognizes the right to information of the victim in a very accessible and comprehensive language about their rights in the proceeding, and also to have information about the status libertatis of the offender. This is for the protection of the victim. So the idea is to fix minimum rule for the support, protection, and also to have access to justice in all European area whenever the crime has been committed. We are facing, we may say, the monitoring phase, because there is ongoing the evaluation of the impact of the directive. And this evaluation has demonstrated that most of the expected benefits have been achieved, but also some shortcomings. And so it's necessary to step further for better recognize access to justice for the victim. This is why some of these provisions are written in a general way that leaves large margin to the state member to interpret this disposition in the implementation phase. Personally, I think that the big challenge is to find the right balance between the safeguard of the rights of the victims, but at the same time, the safeguard of the right of the defendant, because it is covered by the presumption of innocence. And it's a very sensitive issue on the shoulders of different subjects. On the shoulder of the European legislator that has to fix minimum rule in the European area, on the shoulder of the national legislator that had to implement the rules from the European, that sometimes are in a wording quite general, so to be interpreted, and then on the shoulders of the judges and prosecutor as well. They have to apply and interpret the rule, the domestic rule and the European rule. And sometimes they have to verify if there is consistency between the European rule and the domestic rule. And they have the extraordinary, exceptional mechanism to ask to the Court of Justice for an interpretation, for a preliminary ruling, when they have the doubt that there is conflict between the European rule and the domestic rule. I can mention, for example, a case decided by the Court of Justice, the Gambino case. It's decided in 2019. It was about the principle of immutability or immediacy. This principle is, states that the right of the defendant to be confronted with the witnesses in front of the same judge that will decide the case. So when the witness is examined, for example, by a panel of judges, and subsequently the panel changes, if the party don't give the consent to use the record of this examination, the witness has to be reheard, because this is a principle of the defense. And in Italy, when you do not respect this principle, the decision is null or void. In the specific case, the Italian court, the referral judge, asked the Court of Justice for a preliminary ruling, because in that case there was a victim examined by a panel of judges. The panel changed it. So the defendant didn't give the consent to use the record, and so the victim has to be reheard. In this case, the judge asked the Court of Justice, could be a violation of the right of dignity, protection of victim to secondary victimization, because there is a specific indication in the directive to keep the examination of the victim at a minimum number, not to examine and re-examine the victim, but this could be an offense, a damage for the victim. In this case, the Court of Justice, starting from the legal basis, that is the directive, observed that the rule to keep the examination at the minimum number referred to the criminal investigation. So the court noticed that there is a big difference between criminal investigation and trial phase. So at the end, the court said that there is the right of the victim to be protected, yes, but at the same time, this right can't hamper the right, the same right of the defender to be judged by the same panel of judges that have heard the witnesses. So in this case, the principle drawn from the judgment is that is not against the directive a national legislation that asks a victim to be reheard when there is a change in the panel, when the other party don't give the consent, when we are in the trial phase, but the judges has to ascertain if the victim has specific vulnerable situation. So to find a balance. In that case, the rule was, yes, it was possible, and it was according also to national, European law.